Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Robert S. Bernstein discusses mediation.
Mediation comes under the heading of alternative dispute resolution. Alternative dispute resolution is a broad category that includes mediation, arbitration, early neutral evaluation, and maybe some other things, but those are the three main things that people talk about. And those are ways to resolve disputes outside of court or in conjunction with a court proceeding. Mediation, which to me is the most important of those things, is a facilitated settlement discussion. It's entirely voluntary among the parties. Although a court may order the parties to go to mediation, the result is voluntary. So it's voluntary among the parties. There is a mediator who is a neutral party, either hired by the parties or directed by the court to be the mediator, who helps the parties come to an agreement if possible. That mediator has gone through special training and presumably has had experience mediating cases so that he or she can help the parties to have a meaningful discussion. Sometimes the discussion is facilitated best by the parties not being in the same room. Sometimes the parties should be in the same room. Typically, when I mediate a dispute, I have the parties all in one room together at the start. I make some introductory comments about the mediation process, including the fact that everything said there is confidential and cannot be disclosed to the court or anywhere, so that the parties can be free to have an open discussion. I make these initial comments. I often ask each side, whether by their attorney or by one of the parties, to make an opening statement, to say whatever they want to say about the dispute, about the possible resolution, about their feelings about the dispute, so that they can, in some sense, get it off their chest. It may be hard for the other party to hear because there may be things said which may be hurtful. Hopefully they're not, but they might be. But it's important for the resolution process for people to be able to say what they need to say and get their feelings heard. Oftentimes in court proceedings, parties don't feel that they've had an opportunity to be heard. And so mediation allows that. After the parties have given their opening statements, depending upon the feel, I might ask for discussion to happen right then and there. I will have consulted with counsel on both sides or the parties to get some idea of the settlement positions confidentially provided to me before the mediation. And I may feel that things are close enough or maybe far enough apart that there ought to be some discussion right then. Either after that or instead of that, I'll separate the parties into separate rooms and will then shuttle back and forth, talking to the parties privately and confidentially about their positions, about how the case may be settled. And this allows me to perhaps fashion a settlement that I can suggest to each side based upon what each side has said in order to help them come to an agreement. At the end of that session, if there is an agreement, the parties will help me write it down so that there is an agreement that can be signed so that the case can be resolved either back to the court for a final order or final judgment, or if there's no court involved, for a final agreement. But at least at the end of that day, we'll know that the mediation accomplished a settlement.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.